I have a lot of experience both in civil court doing consumer cases as well as with housing cases. So we're gonna we'll see how long I last before my voice needs a break, and we will take a short break, and then we'll come back and finish whatever is left of the training, and then we'll continue until we're done. Okay. So, oh no, it's not letting me move the slide for some reason. Okay, give me 1 second. I just need to, something is not working right.
Take your time. I'm going to go ahead and put it in the chat for everyone to follow along.
View. Reading view. Okay. Usually that works. Okay, here we go. So these are the goals of the training, just to give you a sense of what we're going to cover. By the end of the training, you should know how to recognize and answer a summons and complaint in a civil court action, court procedures in civil court and how they differ from housing court, common defenses in rent arrears cases in civil court, your choices on how to resolve the case, settlement, dismissal, or discontinuance, or trial, how to prepare for your court date to make it more likely you will get the outcome you want, and the basic definitions of legal terms used in civil court and common stipulation provisions. So just to let you know, I did a sort of glossary of legal vocabulary, and I just stuck it at the end of the PowerPoint. It seemed too long to go through all of them. So I'm going to define terms I think people might not be familiar with as we go along. And just for future reference, if you need to look back or look up words you're not familiar with, if you end up in civil court, you can just go to the end of the PowerPoint training for that. So here's some of the main differences between housing court and civil court. When you're in housing court, they're eviction proceedings. So the judges have a right to evict you. That's not true in civil court. In civil court, it's all about money, and that's all the civil court judges can do. They can issue a judgment against you for rent arrears, but they can't evict you if you don't pay rent that's owed. Another important difference is that there is no right to counsel in civil court. So if you go to housing court, in theory, you have a right to counsel if you are eligible for a free attorney, but there's nothing comparable to that in civil court cases. There are some volunteer lawyers available, but often they do not do the rent arrears cases. I'll talk a little bit more about that later. So generally, if you're in civil court, you're on your own. Judges in civil court who hear cases involving unrepresented defendants. Defendants are the people that are sued, as opposed to plaintiffs, who are the people that filed the court case to sue someone. There is a room in civil court where they put all the unrepresented defendants without attorneys, and the judges in that room tend to rotate in and out on an irregular basis. So it's possible that you could see a different judge every time you go to court. In housing court, in contrast, the judges are generally assigned to a particular room, and that is changed, on an annual basis potentially, but for that year, you're pretty sure you're going to see that judge. Civil court, you have no idea who you're going to see before you get to court that day. Civil court judges tend to have limited knowledge of housing law. There aren't many of them that have spent time as housing court judges, though there are a few. And housing court cases just don't come up much for them, so they haven't really had to learn that area of law well. Another big difference is that parties in a civil court case have a right to what is called discovery, which is the exchange of information. That's not true in housing court. In housing court, you have to ask the judge's permission to seek information from the other side, but in civil court, it's automatic. And we'll talk more about that later on. And there are many fewer resources, legal resources available to help tenants who have been sued in civil court, which may be one reason why landlords might be suing more tenants there. So when are you at risk of being sued by your landlord in civil court? These are examples of the most common scenarios that I see in civil court cases involving rent arrears, but there are more than this. It can come up in a lot of different contexts, but just to give you a general idea, it's frequently when you moved out of your apartment before your lease ended, or if you moved out in the middle of a housing court case and there was no final resolution saying that you didn't owe any more money to the landlord. You can also be sued. There's some charges that a landlord can't sue you for in a housing court, so they have to sue you in civil court. That tends to be money related to late fees, utility fees, legal fees, or repair charges. It often also comes up that the landlord may have started a holdover proceeding against you in housing court. That's when they're suing you for a reason other than not owing rent. It often comes up, at least for rent stabilized apartments, when someone is claiming succession rights after the original tenant or the tenant of record has moved out, and the landlord often stops accepting rent after they file a holdover proceeding. And so because they can drag on quite a while, no one's paying the rent for sometimes month after month after month. And then once the case is resolved, the landlord may sue you for the months of rent that you were in the apartment. And if there is no lease, that rent is called use and occupancy. It's usually the same amount for the time that you were living in the apartment. The other time it comes up is if you had a lease, you moved out and you left somebody else in the apartment, so it couldn't be re-rented. Maybe they promised to pay the rent, but something happened and they didn't, but your name is still on the lease, and so the landlord's going to go after you, even though you weren't living in the apartment at that time. And occasionally they file cases because there is an agreement from housing court where you admitted that you owed rent, and that you were willing to, and you agreed to pay the rent arrears, and they're bringing the case in civil court to enforce that agreement. So are you going to get any warning before a landlord starts a court case in civil court? If you still live in the apartment and your lease requires the landlord to serve you with a notice, usually it's called a rent demand, saying how much you owe before they sue you, your landlord may still have to serve you with a notice, even if they are not suing you in housing court. So if you get a notice like that and it says they're going to sue you, it might be in the form of a letter, it can show up different ways. But if they say, you might get a letter that says, hey, you owe us this money, and if you don't agree that you owe it, contact us. And if you don't, we're going to sue you. If you have a Section 8 voucher, the landlord may have to send a notice to Section 8 before suing you in civil court for rent arrears. If the landlord employs a debt collector, including a law firm that regularly collects debts by filing non-payment cases in housing or civil court, and that's most landlord attorney firms or law firms that represent landlords, the debt collector has to send you a notice of your right to ask for verification of the debt and your right to dispute owing the debt. Verification is basically documentary proof to show why they have a claim against you for rent, and what they have to provide varies, but generally it would have to be like a copy of the lease if they're saying you owed money pursuant to a lease, or if they say you signed an agreement agreeing to pay money, a copy of the stipulation, that kind of thing. In order to have the debt collection process stop while that verification request is pending, you have to ask for the verification in writing. And it does stop collection of the debt, but it doesn't necessarily stop them from filing a court case against you. It can stop them from sending you letters saying pay up, pay up, pay up, which is often what people experience in civil court types of cases. One good idea is if you are going to request the verification, let them know if your income is exempt from collection, which means that it's protected from debt collectors by law. That may persuade them not to file a case in civil court against you, because if they can't collect the debt from your income, it's really not worth the time and effort to sue you. So a lot of people don't know what kinds of income are exempt from debt collection. So I made this little list. These are not the only types of income that are exempt, but these are the most common ones. Social Security, including just retirement, Social Security, SSI, SSD, other government benefits such as unemployment, public assistance, often COVID relief, the family tax credit, that money was exempt from debt collection, foster child payments, child support, alimony. I think if you get a subsidy for adopting a child, that is also exempt. Other types of retirement benefits that are not Social Security, so payments from a pension, or withdrawals from a 401k, an IRA, or a 403b accounts are exempt. Workers' compensation. Generally, I think people are familiar with the concept of wage garnishment, which is when somewhat you owe a debt and the person gets the legal right to collect the debt. They can contact an employer and ask them to take a certain amount out of your paycheck every week until the debt is paid. So the law does protect income up to $450 a week take-home pay from wage garnishment. So they can't touch your paycheck if your take-home pay after mandatory deductions like Social Security or Medicare taxes is $450 a week or less. Now, if you have voluntary contributions, like you pay something to go into a retirement account, for example, that doesn't count. That money is still included. It's not excluded from calculating the $450 figure. So for example, if you get paid $500 a week, but $50 a week goes into your retirement plan, so that brings it down to $450, your wages can still be garnished because they were higher than $450 before taking voluntary contributions into account. So this can be a little confusing, this one. So it's sort of a rule of thumb. And I give you a website to go and look at where they have a much more thorough explanation of that. If you find yourself in that situation. Also, in terms of bank accounts, if a debt collector has the right, or a creditor has the right to collect a debt from you, this is how much the law protects of income or money in your bank account. This again is highly confusing. I don't know why they did it this way, but if you don't have any government benefits in your account, the law protects up to $3,600 per bank account. So if you have $3,600 or less in your bank account and no government benefits, they cannot freeze your bank account. If you have some kind of government benefits in it, whether or not you have other types of income that are not government benefits, it reduces the amount to $3,060. These figures are based on the minimum wage. It's a very complicated formula. I'm not going to bore you with it, but it does change from time to time. So this is what it is right now, but it could go up if the minimum wage changes. And this website, the New Economy Project, they keep up to date flyer on that, a handout that you can download and keep for reference. Now, how can we avoid a lawsuit for rent arrears? It sort of depends on the context and the circumstances of why you're being sued, but these are some general categories that I see frequently. So if you are moving out, you can often, what I have seen happening is landlords claiming after tenants move out that they owe rent arrears from before the time they moved out, or because they damaged the apartment and the landlord had to spend money to before on it more than normal wear and tear to repair things that are more significant than normal wear and tear. So that's usually when this comes up. So how do you avoid that? You can ask for a pre-move out inspection. You're entitled to one by law. so that you can do a walkthrough with the landlord, show them that the apartment is in good condition, and resolve any disagreements about whose fault if it is not in good condition at that time. So the landlord under the law cannot use your security deposit to make repairs that are the result of normal wear and tear in the apartment. So just the ordinary consequences of living in an apartment. So, if they eventually paint starts peeling and chipping, it's not anything anyone did wrong. It just wears out. Finishes on floors, same thing, all that kind of thing. The other things you're not responsible for is repairs because the landlord has failed to maintain the apartment or make repairs. So if there was a flood from the apartment above you and it ruined the floor, you had a wooden floor and it's now just in very poor condition, the landlord can't charge you for that repair. That was not your fault. Once you do the inspection, and you move out, they have to provide you with a notice to let you know if they are not going to return your security deposit and state why. And they're supposed to do that within 2 weeks. And then if they don't, they may have given up their right to get any of this, to hold back any of the security deposit. So that's just kind of for your information. It's a little beyond the scope, but it comes up a lot. If you move out before your lease is over, technically, the landlord can hold you to have to pay the rest of the lease. So if your lease runs from January to December and you move out in the middle, like in June, technically the landlord could sue you for the months left on your lease for the rent that you would have had to pay if you'd stayed in the apartment. Ways to avoid having to deal with that situation is get it in writing if the landlord agrees to let you break your lease, including whether they've waived any rent arrears and when your obligation to pay rent ends. So if you're moving out in June, you wanted to say that after June, you don't owe any more money on that lease. And if you turn in your keys, you're going to want to ask for a receipt. It can just be a piece of paper and they say keys received and have somebody sign it. It can be the super or the management office, wherever you turn the keys in. Another thing, sometimes this comes up when you're in court and you've agreed to move out rather than pay rent arrears. So I think I discussed this later, but you also want to put everything in writing. I see a lot of tenants who come to me because they've been sued after they moved out, and they thought if they moved out because they were told they owe a certain amount of rent and they were given a set period of time to pay it. And when they couldn't pay it, they moved out. They thought that would take care of the problem. It doesn't erase the debt. I will talk more about that in a later slide, but just to give you a little preview. So how to avoid that? I guess that is this next point, actually. Sorry, it's been a long day. So how to avoid that? If you move out to avoid an eviction after a case has been filed against you in housing court because you owe money, you can negotiate an agreement that the landlord will give up on the rent arrears and release you from release before you leave, and then file it with the court, and then they won't be able to sue you later saying that they didn't agree to do that and that you still owe that money. If your landlord stops accepting rent, that's pretty common if they filed a holdover case against you. But it can also happen if your lease expires and they don't want to renew it, or if they're just harassing you. Sometimes that's a form of harassment they use to try to get people out. Set the money aside. Just because they don't accept it doesn't always mean you don't owe it. So don't spend it. Keep it someplace safe. Set it aside in an account, a checking account if you have it. If you're in court, when this happens, you can ask to pay the money into court instead of to the landlord. And then you'll have a record that it's been accepted. If you're in court on a holdover, you can ask the court to order the landlord to accept the payments. And they would, again, if you're in a holdover, it's called use and occupancy instead of rent, because technically when they file a holdover, they serve you with a notice that terminates your tenancy. And so it kind of canceled the lease out. So it's called use and occupancy. If you can afford to pay it, try to keep paying it. I know some people want to hold that back in case they have to move. But if you're going to be sued later for like $10,000, like, that's not going to be helpful. It's better to try to resolve it when you can, if you can. Sometimes you just don't have the money to pay. If the landlord is not recognizing you as a successor tenant, they can sue you for use and occupancy for the time before they gave you a lease. It used to be back in the day when I was doing housing law, landlords didn't do that. It was just like if they didn't charge you, if they wouldn't take your rent and they dragged out a holdover for like a year or more, claiming you didn't have a right to the apartment, and then they lost at trial. There were court cases that said that they couldn't sue the tenant, the successor tenant, for rent arrears because there had been no lease in effect. But unfortunately, they can't sue you for rent, but they can sue you for this thing called use and occupancy, and for for the value of being able to use the apartment during that time. So even though landlord, and they always could do that, but they didn't used to bother. But now, for whatever reason, they've decided they will. So I see some cases in that category. When we're talking about breaking a lease, there are some laws that protect certain categories of people from penalties if they do move out before a lease ends. And that includes service members on active duty, domestic violence victims and survivors, and senior citizens in certain circumstances. So if you find yourself in one of those categories, you would want to investigate that before you move out and make sure you comply with any notice requirements in order to get the protection of those laws. So that's just, again, there's so many crazy variations on how these cases come up that this is just a random sampling of the more common ones. So this is not the only thing. One thing I don't see on this slide, and I do think I mention it later, but just to highlight it for you now, if you move out before your lease is over, there were changes in the law in 2019 that said that the landlord now has a duty to try to release the apartment to, it's called mitigate damages, but it basically means that they can't just not rent the apartment for the 6 months left on the lease and then go after you for it. They have to at least show that they've tried to re-rent the apartment. And we will talk about that more later. So back to civil court and how it works. The commencement of a civil court action. How does it begin? The landlord files a paper called a summons with a civil court clerk who assigns an index number. The summons has basic information, names and addresses of the parties, the person suing and the person being sued, the address of the court the case has been filed in, and information about how long the tenant has to answer. It generally has, it says summons in big letters on it. And that's how you can tell if it says summons on it, it's not a housing court case. Housing court doesn't issue summons. So that's a clue you're not being sued in housing court, even though if you read the papers, it will say it's about rent. The landlord has to serve you with a copy of the summons within 120 days of filing it with the court. And there are 3 ways it can do that: personal service, substituted service, or conspicuous placement service, which people often call mail and mail. We're going to talk about those more in a moment. How long the tenant has to answer the summons depends on how it was served. And one additional note, most landlords serve the complaint, which is what has the details of the case, the facts supporting their claims, like why they sued, how much they're suing for, why they say you owe the money. Most of the time they give you that paper at the same time as the summons. I see I wrote as the summons and complaint. That's wrong, as the summons. If they don't, you have to ask them for it. It's pretty uncommon, but it does come up. So I just wanted to mention that. The different ways you can as promised, explanation of the different ways a landlord could serve you with the summons and complaint. So one is personal service. That's easy, right? They give it to you personally. They like show up at your door, they knock on the door, you open the door, they say, you've been served. They don't necessarily, generally, they're supposed to try to serve it to your actual residence, but they can also serve it to you where you work or someplace called the usual abode. And that's a little harder to define, but it's someplace you spend time at regularly and you're there on a regular basis, but it may not be where you actually live. So maybe you have your own apartment, but you spend like 80% of your time with your significant other. So maybe under those circumstances, if they can't find you at home, maybe they could serve you at that place. Substituted service. That means if they go to your home or your place of work to try to serve you and you're not home, but somebody else is that they think they could reasonably expect to give you the papers, they can serve that person as a substitute for you. That's where this substituted service comes from. There's a lot of fighting over who is a person of suitable age and discretion. And it really depends on the individual facts and circumstances. So obviously they can't give court papers to a 3-year-old and really expect them to give it to you, but they might be able to give it to someone under 18, like maybe a 14-year-old, or if it's at a workplace, a receptionist or a coworker. For nail and mail, they can only use it if they've made multiple attempts to serve you in person, with at least one attempt being outside normal business hours, like on the weekend or before 9 or after 5. They have to attach the court papers to your door using tape. It's not enough to just kind of prop it up, which is what happens a lot of times. And they're not allowed to just leave them somewhere in the building or on the front door, for example, of the building. They're supposed to bring them to your apartment door. And for any service that wasn't given to you, any papers that weren't given to you personally, they have to mail you a copy. So for nail and mail and substituted service, they also have to send you a copy by mail. So how long do you have to answer? You get these summons, and the summons says in big answers that you have to come to court to file an answer. And it has this very paragraphs of like how long you have, which can be very confusing. So this is just the summary. This is the bottom line. If you were served personally, you have 20 days after they handed it to you. That's how long you have. If they gave it to somebody else in the apartment, you have 30 days. If it was left on your door, 30 days. So make a note. If you get served with a summons and complaint, like note down the date you got it, because that's going to determine, well, the day it was served, that's going to determine when your deadline for filing in court. Sometimes people are out of town and they come back and there's a notice on the door. They have no idea when it was served. Like, then just go as soon as possible. One tip is that the date on the summons is the date that they signed it. It's not the date it was served. I have people a lot who come and tell me, this is dated in January and I didn't get it till April. That's because they have, the 120 days to serve you. So they don't always give it to you right away. They file it with the court and often they just kind of sit on it for a while. So what do you have to do to answer? If at all possible, try to talk to an attorney. There are legal services organizations listed on this website, lawhelp.org/NY. You can also call the court's legal resource office for help. You do have to go in person, I think, at this point to get that help. And often there's a long line and they limit how many people they can see in a day. So it can be challenging, but it's generally very hard for people to navigate this if they're not familiar with civil court. So if you can, speak to an attorney. But if you can't, file your answer. Do not wait. If you do not answer on time, they might enter a judgment against you, because if you do not answer within a certain time frame, the court will assume that you agree with the allegations and you don't want to fight the case. And so they'll give the person that sued you whatever they want, whatever they say you owe. The summons will say the location of the court. So that's how you know where to go to file your answer. In New York County, which is where I practice, it's on the first floor in room 118, but every borough has its own particular location. So you'll have to check on the form to see on the summons to find out. And if it's not clear when you get to court, you can ask a court officer and they'll direct you to the right place. When you get to the court clerk's window, if you haven't already filled out an answer form with the help of an attorney or the Legal Resource Center, they'll give you a form to fill out, and you'll have to write down your answers, write down your defenses, which are why you think you do not owe or should not have to pay the rent arrears. And you can also include any claims you might have against the landlord. These are called counterclaims, and we're going to talk about them more in a minute. You may be told it's really inconsistent. Some of the clerks will tell you that you have to have the answer notarized when you sign it and serve a copy on the landlord before you file it with the court. And other times they'll just let you sign it in front of the clerk and they will serve the answer on the landlord. So it can be a little frustrating. So you may want to try and call the clerk's office if you have questions before you go down there, if it's inconvenient for you to go there, but it can be really hard to reach someone on the phone, unfortunately. Once you file your answer, you're going to be given a court date and they'll tell you what room you have to go to on the court date. So let's talk a little bit more about defenses. So one of a very effective defense and something that's very common is that tenants often, or defendants in general, often are not served properly. They're not given the court papers in the manner required by the law. And when that happens, the court lacks the authority to hear the case. So the case has to be dismissed. So that is a really good outcome for people, especially if you owe the debt. And so you don't have a reason to say that you don't owe it. You have no defenses. Not being served properly is something you definitely want to bring up. Another common defense is breach of warranty of habitability. What does that mean? Over the years, courts have decided that when a landlord rents an apartment, there's basically an obligation for the landlord to make sure that the apartment is livable. And even if it doesn't say that in your lease, that you have a right to a livable apartment. And if the landlord doesn't comply with that obligation, it's called a breach. Not doing what you're supposed to do under a contract is called a breach. So you don't have to worry about breach of warranty of habitability. You can also just say there are repair problems or bad conditions in the apartment, but technically breach of warranty of habitability is what that's called by lawyers. Other common defenses that are, you don't owe the debt. You paid it. Or you dispute the debt, you disagree that you owe the amount they say you do. Maybe you made payments and they didn't credit you. That is one example. There could have been a rent overcharge. We were charged and paid more than the legal rent. So how can you owe anything? Because you overpaid. The landlord, this is the defense I talked about a little bit earlier, that if you broke your lease and the landlord's suing you for the months left on your lease, you can say as a defense that he or she or it didn't take good faith steps to mitigate the damages. So if you know, or that maybe they re-rented the apartment, because once they re-rent the apartment, even if your lease isn't over, you're no longer responsible for the rent. So one defense would be they re-rented the apartment like right after I left. So they weren't out any money because I moved out. And the other thing is like they could have re-rented it if they tried and they didn't. So, they weren't acting in good faith. They weren't acting as the law requires them to do. Sorry, I prematurely moved that. All right, waiver. Maybe the landlord told you, hey, if you move out, I'll forgive the rent arrears. Or sure, you can break the lease and you don't have to pay the rent. So if there was some agreement on that, you can put that down too. Constructive eviction. That's when the repairs in the apartment, the conditions are so bad and the landlord has refused to repair them so that you couldn't live there. You literally couldn't live there. It's not, this can't be for minor things. It has to be like ceilings falling down or floods or, mold in all the rooms. It has to be serious. But if it's really made the apartment unsafe to live in, like you can move out and you're not supposed to, the law says you don't have to pay rent. It's basically, they didn't take you to court to evict you. They just let the conditions get so bad that you had to move out. That's what constructive eviction is. Statute of limitations. This doesn't come up too often, but it's if the landlord has waited really long time to sue you, they might have waited too long. So for example, the law says the landlord has 6 years from the date that the rent became due to sue if you don't pay it. So if they waited more than 6 years to pay you for the last rent that was owed, it's too late. And you can ask the court to dismiss the case. In violation of the duty of good faith and fair dealing, that means the landlord was dishonest or unfair in their dealings with you in some way related to the apartment. Like maybe they rented you an apartment that was illegal, you didn't know, or they said they would put in a stove that worked and they never did, or they said you could move out and they wouldn't go after you for the money, but then they did anyway, that kind of thing. If you have a defense of improper service, they didn't give you the court papers the way they had to, you're going to want to look at the affidavit of service in the court file. So after you're served with the court papers, the person that served them on you has to file an affidavit, which is a sworn statement of how they served you in person, substituted service, mail and mail, and they have to include certain information on it. If they served a person, they have to describe the person and say the time and the date. And if they just nailed it on your door, they still have to give some description, though it's not of a person. Obviously, it's maybe the color of paint on the apartment door or the hallways, that kind of thing. Often the affidavit of service is not going to be filed before you go answer. So you may not be able to look at it, but ask anyway. And if it is there, when you do your answer and say, I didn't get the papers, include the facts to say why what the process server said was wrong. For example, it's really common for process servers to lie on these affidavits and say they served somebody else that wasn't you in the apartment. And they might identify that person as like your Aunt Susie or a co-tenant, and they'll describe them. And maybe you live by yourself and you have no Aunt Susie. So you want to say those things. Or they say they served you and they said you're really tall, but like you're really short, something to show that they didn't really see you. They didn't really go to the apartment, because if they had, they would know the stuff they put in the affidavit was wrong. If the affidavit of service isn't there, just write down what you know. So what do you know? You know that you didn't get the papers, and you know that no process server came when you were home. If you weren't served in person, you may know that no one else could have been served, like if you live alone and there was no one else to take papers on your behalf, or you never found a copy pasted on your door. If you find out more later, you can always add more stuff. You have a right to amend your answer for a period of time after you file it, and after that time elapses, you can also just ask the court's permission, and they're supposed to freely grant it. So don't worry about it too much, but the law requires you to, if you want to challenge service, you have to give specific facts to show why you have a right to bring up that defense. So it's a good idea to put in as much detail as you have, because if you don't, then the other side might try to ask the court to strike that defense, which basically means remove it from your answer. Okay, now we're on to counterclaims, your claims against the landlord. So one could be for a rent abatement. You can ask for a rent credit for months when there were really bad conditions in the apartment. If you paid a security deposit and the landlord didn't return it to you when you moved out, you can ask for that to be returned with whatever interest you earned on it. If you believe there was a rent overcharge, you can ask for a refund of any rent paid that was more than legal rent for the apartment. Rent overcharge applies to rent regulated apartments like a rent stabilized apartment or rent control. It doesn't apply to circumstances where the landlord's just charging an outrageous rent for an apartment. Unfortunately, they're allowed to do that. You can also sue for property damage, like if there was a flood in your apartment, because the landlord didn't fix a pipe in the wall or what have you, and it damaged your furniture, you can ask to be compensated for that damage. Okay, preliminary conferences. So you got served with the papers, you filed your answer, you were given a court date. So now we're like, what happens on the first court date? The first court date is called a preliminary conference. And it's different boroughs have different court procedures. And so I can't tell you exactly what's going to happen when you go to the courtroom, like that you're assigned to that day. But I can give you a general idea of the possibilities. So in your county, for example, this is the second bullet point, there's a calendar call. So you go and you look at the calendar that's hung on the wall out in the hallway outside the courtroom, and you look for your name, and there's a number, like a single digit number next to the case name. So it'll be like evil landlord versus Mary McCune, and it'll have a number 1 to the left of evil landlord, and it'll say like number 4 on the calendar. So they'll call the cases and they'll say like evil landlord versus Mary McCune. And when I hear my name, I have to say defendant or indicate that I'm there. And they call the cases in order. So if you know the calendar number, you know a little bit, like if they're going to call you very quickly or if you're near the end, which can reduce your level of anxiety a little bit if you know when you're going to be called. In other boroughs, you may just get your calendar number from the list of cases and just go in and talk to the clerk and give them your number, and they'll just check you in, and nobody ever calls your case. And I think this is very similar to housing court, but the court isn't going to hear your case. The judge isn't going to talk to you until both sides are present. So in New York County, which is Manhattan, if I didn't say before, what they do is after they call the calendar, they see which cases have both sides there, and then they'll call the cases where both sides are there up to talk to the judge. So maybe like calendar number 1 and 2, nobody answered, but 3 did. So they'll call the number 3 case first. And generally in Manhattan, you talk to a judge. I think that's true in a lot of the boroughs, but I think sometimes the judges delegate and they have you talk to an assistant who is called the court attorney, and they work for the court. They're not there to represent you, but they're there to sort of act in place of the judge during sort of preliminary conversations. Cases are frequently adjourned when they're still in this preliminary conference category. So you may have multiple dates that are called preliminary conferences. Okay, let's see why. Oh, there we go. So I know people may be getting a little tired, so I'm gonna try to have a break probably a little after 3, so people can just get up and stretch, get some water, go to the bathroom, whatever, just so you know. Okay, how to prepare for a preliminary conference. This is the first chance that you'll have to speak to the other side about the case. From the court's perspective, their main interest is to see whether the case can be settled or not. without any further intervention. It's really common for the judge to ask if you agree that you owe the rent arrears or whether you want to settle the case. And you may not want to answer either of those questions. So here are some strategies for what to do. If you're not ready to really talk about settlement, or if you're not sure you want to settle, you can ask for an adjournment to speak with an attorney. And I seem to have left out a word here. So just ignore that. You can also say that you can't discuss settlement at this time. You're not ready to because you need more information from the other side. Maybe you've been sued for rent arrears that you don't think you owe. So you want them to give you proof that you owe this money to show why they think you owe it. And in that case, you can ask the court to issue a discovery order. And we are going to talk about discovery soon. But basically, the court can order the parties to exchange information on a timeline and set a specific date. So you could, if you want information from the landlord, you can say, I need them to show why they think I owe this money. I don't think I owe it. And so the court can adjourn it and say, get them papers by whatever date and give you something in writing to that effect. If you feel like you owe the money and you agree with the amount and you don't have to be running back and forth to court and you have the ability to pay something on the debt, you can try to settle the case. And you can do that on your own, talking to the attorney for the landlord, or you can ask to do that with the help of court personnel. In some boroughs, it might be the judge that talks to you both about it. And sometimes it might be someone else like a court attorney. Every case is different, but it is often better to wait to try to settle the case until after discovery, because you may, and I'll tell you why in a minute. What we've all been waiting for, discovery. Discovery is the exchange of information between the parties. It takes place before the case goes to trial. In civil court, unlike housing court, as I mentioned earlier, it's automatic. You don't have to ask for permission. You have a right to ask for physical records and documents. You have a right to serve what are called interrogatories, which are written questions that the plaintiff has to answer in writing and sign before a notary to say that they're correct, the answers that they've given. And you also have a right to depose the landlord. That's an interview where the landlord or their representative answers questions before a court reporter who swears them in. So they're answering under oath. You don't see that a lot in civil court because it's very expensive and the parties have to pay for it. So if you want to depose your landlord, like you would have to pay, several $100s in order to do that, to pay for the court reporter. And you'd also have to find a place to do the deposition. It can cost a lot. Take my word for it. Asking for records and documents, that's really common. Interrogatory is a little less common. You don't need a court order to be able to serve these on the other side. You can just mail them a list of your demands saying like, send me this stuff and naming the documents you want. Like, I want the lease. I want a rent breakdown. I want, whatever else you think could be helpful to you. And same thing with the interrogatories. You can just write a list of questions and mail them. But the landlord also has the right to ask you for the same things. So if you get discovery requests from a landlord, it is often a really good idea if you are able to consult with an attorney before you respond to them. There are limits on what people can ask for, and it's really common for plaintiffs to sort of go above and beyond what they're legally entitled to ask for. One thing that can happen after discovery is you can maybe find out that you have defenses you didn't know about. So you can always, like I said, ask the court for permission to amend your answer, which just means adding more defenses or claims. Okay, more on discovery. A lot of the judges right now in civil court have what they call a discovery order that they will sort of automatically issue at a preliminary conference that will state the documents the plaintiff has to produce and by what date. They're often designed for consumer credit cases, which are transactions which are credit card cases. So sometimes the vocabulary doesn't really match what goes on in a rent arrears case. So it may not, you may want to ask the judge to make it like a little more specific. And it usually just says they have to produce all records related to the account. But some of the other stuff they say is like terminology that just applies to credit card cases. Like I won't go there. It's too complicated. But anyway, just if you read it, it doesn't make sense, feel free to ask and to ask the judge to make it clearer. If you don't have an attorney, it may be easier to ask the judge to issue a discovery order than to write and send your own discovery requests. Like if the judge gives it to them in court, they can't say later they didn't get it. But a lot of times the landlord attorneys show up and say they never received it, even if you mailed it. So that can get rid of that issue. And also, if you don't really know what to ask for, you know, at least if the court does it, they use the terminology that the judge recognizes, and they can, it's got a date on it. So it's easier for you to say, look, like the judge gave it to them on this date. They had until this date to do it. They didn't do it. Then if you mail it and you think they got it by a certain date, but you don't know for sure. If you have raised financial hardship in your answer, like saying like, you know, I want to enter into a payment arrangement, but I can't, or the reason I stopped paying was because of a death in the family, or I lost my job because of COVID, or what have you. That comes up a lot in credit card cases. It's less common in rent arrears cases, but a lot of these discovery orders, because they're sort of one size fits all, will also order you to submit the hardship application to the landlord to see if they will waive some or all of the rent arrears. And those, it depends on who you're being sued by. Sometimes there is no specific form to fill out. They just want you to explain why you can't pay. Some of them want you to do a sworn statement and sign it in front of a notary. Some of them want to know, like, what are all your debts? What are all your assets? Like, how much do you have in your checking account? How much, you know, what are your monthly expenses? So it's not really defined, unfortunately. But if they say they'll consider it, you know, and you owe the money and you can't pay it, it doesn't hurt to put it in. But you don't have to tell them your whole life story, and you don't have to answer financial questions about anyone other than yourself. If they're, a lot of times they want to get your spouse's information, but if your spouse isn't on the lease, they're not responsible for your debt. I don't know if you can hear the sirens like outside my window, but if you can, sorry, it should be over soon. So what are some of the reasons that you should ask for discovery? To get records from the landlord that you can use to prove your defenses. So if you're sued after you moved out, you may not have kept your lease or your rent receipts to prove that you made payments, or copies of violations placed on your apartment, but maybe the landlord has a rent ledger and it shows the money order numbers and when you paid them, and you can use that to say, see, I did make the payments. Or maybe they have copies of notices from HPD or letters that HPD sent them about violations. If they said, nobody told me about the repairs, but if they have violations, they must have known about them, that kind of thing. And certainly they should have a copy of your lease. You can also maybe find out you have defenses that you didn't know about before. And maybe they might be good defenses. Like maybe you find out they sued you for moving out early and say you owe a bunch of months of rent, but then you ask them for documents and you find out they rented the apartment like the week after you left. So they're not allowed to double dip. If they were getting rent for those months, they can't turn around and sue you for it. The other reason is to find out what evidence the landlord has that they can use against you at trial. That can help you see if your landlord has a strong case. if they have the papers that they need to be able to win at trial. And if they don't, that's going to maybe influence your decision about how you're going to resolve the case. It can also give you more information about their claims. The complaint that they serve on you, it often says very little. It doesn't always even say the months that they're claiming are owed. It just gives like they owe $13,000 without saying like even from what year. And it's also a way to pressure the landlord to settle. Engaging in discovery can be expensive and time consuming. And it kind of forces a landlord to review their documents, or at least their attorney to review them and see if it's really worthwhile continuing the case. Maybe it will persuade them that it's a better option for them to settle or even to give up on it altogether. And what if the other side does not respond to your discovery requests? If you ask them to provide documents and they don't, or they pass the deadline for doing it, you can ask the court to punish them. The court can issue an order saying they have to respond by a certain date if there wasn't a set date before. The court can issue an order that the party can't use any documents that it should have provided to you but didn't if the case goes to trial. So that might keep them from being able to present evidence that they need to win a trial. They can also strike parties' claims or defenses, so they can't raise them at trial. I think when they say strike, it means to sort of eliminate them. So if the complaint says you owe rent and the landlord doesn't give you the discovery that you asked for, even though the court has ordered them to do it repeatedly, the court might just say, okay, you don't get to present evidence on that claim. And then what are they going to do at trial? They can't present any evidence. It can also work against you. That's why it's always important not to respond to discovery from the other side, because if you don't provide answers, then they can say you can't present evidence on your defense as a punishment, the judge, that is. In general, if you want to ask the court to punish them, you need to make a written request called a motion. And that could be a little complicated, but it is possible to do even without an attorney. The court doesn't like to punish people for discovery. It's just something, the court doesn't like to be involved in discovery disputes that often judges feel like it's annoying if the parties are bringing it and like, why can't people just get along? And so the most common outcome is they just sort of say, okay, whatever, maybe they didn't do what they were supposed to do, but I'll give them one more chance, and then they'll set another date. But if the court has set dates and they've just blown through them repeatedly, then it's more likely that the court will impose a more serious punishment. Okay, so I think this is a good place to take a break because it's a lot of information, and I think I need to get a drink because my voice is getting a little hoarse. So let's come back in let's say 5 minutes. Does that work, Monique?
Yeah, that works for us, right, Ash? So we'll see everyone back here about 3:19. Let's say
or 3:20. Let's round it out.
3:20, yeah. Okay. See you all then.
See you guys soon. Okay. So I guess it's 3:20 by my clock, so I'm gonna pick it up again.
Okay, great.
All right, motion practice. So we had how does a civil case start? How do you answer? What happens on the first court date? We talked about discovery, which is a very common phase. And now in addition to discovery, there's something called motion practice. It can happen at any point during the court case up to trial, but more often it happens after discovery has been completed. So a motion, as I mentioned before, it's a formal written request asking the judge to do something that's supported by a sworn statement called an affidavit that basically explains like why you have a right to what you're asking for. So common motions made by defendants, the people who have been sued, are to amend their answer, which means to just add on additional defenses or counterclaims, or motions to dismiss, which are most often for improper service. I think I said before, if someone isn't served as required by law, the court lacks the legal authority to do anything on the case. It's called lack of personal jurisdiction. The court has no jurisdiction, no authority over you. And there's a long history of improper service. It's called sewer service, both in housing court and in civil court, but where, as I mentioned before, frequently process servers make claims that they have served people when they have not done so. And because sometimes it is people's only defense, it comes up a lot. Common motions made by plaintiffs, the people that start the court cases that are suing someone else, is a summary judgment motion. That's a motion asking the court to issue a judgment, a decision in their favor based on documents and statements, evidence that they have in paper form, instead of having to go through a trial and having to call witnesses to testify. In order to win summary judgment, the plaintiff has to show that there's no reason to have a trial. The papers say everything, everyone agrees on the facts, so you don't need any witnesses to come in and testify as to what happened. Tenants, if you're the defendant, you have a right to oppose the motion, which is to make a written response saying why the court should not give summary judgment. And because one of the simplest ways to defeat a summary judgment motion, to get the judge to deny it, is to bring up the disputed facts. And because that is something that most people are able to do without a lawyer, that's what I'm focusing on here. There are other reasons why a summary judgment motion can be denied, including that the plaintiff's evidence isn't good enough or strong enough or doesn't meet certain requirements. But for the purpose of this training, I'm just going to focus on the facts. So if they say in their papers that you owe the money and this, that, and the other thing, and you don't agree with that, you raise that in your opposition. For example, if they say you owe $10,000 and you think you owe $1,000 and you have receipts that they haven't credited you for, if they say they did the repairs, but they didn't, and you have pictures or there are violations, or maybe even the landlord's own documents show that they weren't done, if they claim that you're not entitled to a rent abatement because you never told them there were repairs, so how could they have done them? And you have texts or emails showing that you were talking to the super or someone at the management office. If they claim you broke the lease, but you have something that says, they say, okay, you can move out, I'll give up the arrears. Those are facts that are in dispute. They say you did one thing and you say you didn't, or that you did something else. The main reason that plaintiffs make summary judgment motions is because it's cheaper than going to trial. And if they lose the motion, it puts a lot more pressure on them to settle the case. It just kind of ups the costs of continuing onward, and depending on the amount you owe, it may not be worth it to them to continue. All right, so what are the possible outcomes or resolutions for a court case? One thing is that the case can be dismissed. The court can decide that the case cannot go forward due to a legal issue. That's usually, after a motion, like for example, you said service was improper and the court agreed with you. They don't have authority to hear the case, so they dismiss it and say, everybody go home. Other ways are a settlement or what is called a voluntary discontinuance. A settlement is when the parties come to an agreement about how to resolve the case, and it will say typically what each side agrees to do. And then there's something called a discontinuance, which is when both sides agree to discontinue, to end the action. Even though they may not agree on anything, they agree that this case needs to be over. Trial. That's if you can't settle the case, if it's not dismissed and it's not withdrawn through a voluntary discontinuance, the case is going to go to trial. If the plaintiff can't prove its case at trial, the action will be dismissed. You're done. If the plaintiff proves its case, the court will enter a money judgment for the amount that the plaintiff proves you owed. Money judgments are good for 20 years and can be used to restrain or freeze bank accounts, to garnish wages. That's when they deduct money from your paycheck until the debt is a certain amount per paycheck. So obviously money judgments, that's a hard thing to have hanging over you for 20 years. And they also earn interest. So right now the judgment interest rate is should be 2%, but it still adds up over time. So let's go over those different possibilities. If you wanted to try to get the case dismissed, if you were not served properly, I'm focusing on this because it's pretty easy for people to figure out if they were served properly or not, even without the assistance of a lawyer. It's like you got the papers the way you're supposed to, or you didn't. There are other reasons you can ask to have a case dismissed, but they're very fact specific to the case. So I'm not going to spend a lot of time on it right now. This is just to get you an idea of the most common things you can bring up to try and fight your case if you end up having to represent yourself in civil court. So if you were not served properly, you can ask the court to dismiss the case. You will have to make that motion a written request in writing and say why you want it dismissed and the facts that you believe support that request. You have to attach a sworn statement, which we've mentioned before. It's called an affidavit that states how the service was improper. The affidavit has to include a denial that you were served, and it also has to point out the facts in the process server's affidavit that are incorrect or untrue. And we mentioned that before. He served your Aunt Susie. You have no Aunt Susie. He says you're 5 foot tall. You're 6 feet tall. He or she incorrectly described your hair or skin color. Or maybe you were home on the days they said they tried to serve you and said no one answered the door. Maybe you had broken your leg and you know for a fact you were home for like a month because you worked remotely, you couldn't go to work or anywhere else. So you're going to put those facts in your affidavit. If you give enough support to call the factual support to call the process server's statements into question, the court will order that a hearing be held, which is called a traverse hearing, to see whether or not the papers were served properly. So the affidavit and the motion are to get your foot in the door and to get you this hearing. If it's really clear based on the affidavit that a mistake was made, like they said they served you at an address and that wasn't your address, maybe you won't have to have a hearing, but generally the judges in civil court, they don't like to dismiss it without a hearing. So even when it's really clear cut, that's usually the best you're going to get is a traverse hearing. I don't know why it's called a traverse hearing. It has to do with some legal term from, who knows, probably the Middle Ages. Okay, so if you can talk to an attorney before doing a traverse hearing, more likely you won't be able to. This is just an outline of the general way things go, so you have an understanding. I can't give you legal advice. Like I said, it's really fact specific, but this gives you an idea of how it works. The process server has to show up. They have to testify. They have to bring records related to serving the papers. They have to keep records. I think it's for 7 years now. I'm not 100% sure. So if you're challenging service on a recent case that was filed recently, then generally you'll be okay. Sometimes people find out about cases much later after they've been if there was a court case, they were never served, they didn't show up, a default judgment was entered against them, and then they find out years later when their bank account is frozen that there's a judgment. In those cases, like maybe the process server wouldn't have the papers anymore, but what we're focusing on here is really cases that are being filed now. If you were served in like 2023, like the person's still going to have the paperwork if there's a hearing in 2023. You have a right to question the process server after the landlord attorney finishes questioning them, and you have a right to testify yourself and present any evidence you have to show why what the process server said in their affidavit was untrue. Like, for example, they said they took the elevator, but there's no elevator in your building. You could testify to that. If they described your apartment, if they did nail a mail and they described your apartment door as blue and it's green, you could bring a picture to show the color of your door. The landlord's attorney has a right to question you after you testify. So they will generally try to shake you up and get you to say stuff to make it seem like you're inconsistent. Best thing is to remain calm and we'll go through some tips later. It's really common for process servers not to show up to hearings, in which case you win automatically. It's also common that they don't show up and the other side asks for an adjournment. You can always say, look, I'm here and I'm ready to go, and they've had months to find this person. I shouldn't have to come back. And then some judges will dismiss it and some judges will adjourn it. Depends on the judge. If there is a hearing, the process server shows up, they go ahead and the court decides, you know what? I believe you. The process server didn't do what they said they did. Then the case gets dismissed. It's called, the traverse is sustained. And if the court decides that service is proper, then it was done correctly. They don't believe you for whatever reason. They decide they believe the process server instead. Then the case will just go forward and eventually you will have to either settle it or it will go to trial. Traverse hearings can cost a lot for landlords to do. So if you ask for one, it can put a lot of pressure on them to settle. Because if you owe them $5,000 and they have to spend like $3,000 on a traverse hearing and another $4,000 on a trial if they lose the traverse hearing, they're going to end up losing money in the end. So it all adds up. Other option, the case doesn't get dismissed. It's going to go ahead. You can settle the case. The advantage are you'll know for certainty what you have to do. So if it's all about the money, you'll know exactly how much you have to pay. Whereas if you go to trial, like maybe the court will give you a rent abatement, maybe they won't. You don't know. You also, a settlement, you can build into the settlement terms that say how you pay the money. So maybe instead of having to pay it all at once, you'll pay a certain amount per month. You'll have more control over when payments will be made and in what amount. And obviously you can sometimes get them to accept less than what they claim you owe. The disadvantages are that often plaintiffs are unreasonable when it comes to settlement, especially if they think they have a strong case. And so they won't agree to terms that you can live with. They'll agree to allow you to pay $500 a month, and you don't have $500 a month to pay on a $10,000 debt or what have you. If they think they have a strong case, they may say, like, why should I settle? I can go to trial and ask for attorney's fees, maybe. If your lease says they have a right to attorney's fees if they win a case against you. And because rent arrears cases are usually brought for fairly large amounts, because rent is so high, even a few months can add up, the landlord may think it's worth the risk of going to trial because the amount of the arrears are high enough to offset the attorney's fees they would have to pay for doing a trial. So let's say you decide you want to do a settlement. These are just some negotiation strategies and tips. We all know how to negotiate. I don't care who you are. You may not think you know, but you had a sibling and you had to fight over a toy and whose turn it was to like sit in the front seat, or when you were older, or you had to return something to a store that you didn't like and you got into a fight about it with the clerk. Like, all of us have done some kind of negotiation in our lifetimes, even if we don't know it. So we all have these skills, and we can improve them with some help. The best thing you can do to get a good outcome when you're negotiating is just be prepared. Know your case. The plaintiff's attorneys, they do a volume practice. They're there for multiple cases, and often their clients don't really give them a lot of information. So they show up in court and they know next to nothing. If you are confident in the facts and you can tell them and show them why what they think, what the landlord told them about the case isn't right. For example, the landlord said, you never said there were repairs, but as we said before, you actually have texts or emails, from them acknowledging there were repairs, or, they say, what repairs? We didn't know there were repairs. There weren't any repairs, and you have pictures or printouts of violations. All of that can make the landlord's attorney less confident in their case and less willing to go to trial. They count on the fact that most tenants can't find a lawyer to represent them in these cases, and that they can just bulldoze people because they know the court procedures better. So if you show them that you know your rights and that you're not going to let them roll over you, a lot of times that makes settlement much more likely to happen. Decide whether or not you're willing to go to trial. You're more likely to get a better settlement if you are willing to go to trial, because they never know what's going to happen at a trial, right? But they do know what's going to happen if they enter into a settlement with you, because you guys will have to agree on the terms. So showing them you're willing to take that gamble can make them very uneasy, because they don't necessarily want the risk of going to a trial with somebody who's going to bring up stuff. Somebody who's shown that they know what happened in this case and that they have evidence and they're willing to move forward. That can be very intimidating to a landlord attorney. But if you know you're not willing to go to trial, like maybe it can be for a lot of reasons. It can be anxiety. It can be time. You can't take time off from work. It can be that you think you do owe the full amount and you don't want to risk a judgment being entered against you for the whole amount if you maybe can get them to take some money off, or you want to pay out over time, or maybe you think you owe the money and so you don't want to go to trial, you want to resolve it, you think it's fair that you pay something. Those are all reasons why you might not want to go to trial. So think about it. They will know. If you're not sure, it's like they will sense that. So the more confident you are and show you are in negotiations, the more likely you're going to get a good outcome, regardless of what you want that outcome to be. The other thing that's really important is to know your bottom line. Before you start negotiating, know really think about it. Think about what you think is a fair amount to pay. Think about the maximum amount you could pay per month, the maximum amount you want to pay in total, and that you can really afford. Like a lot of people, they just go in and think they'll wing it. I do not recommend it. If you know your bottom line, it makes you a much stronger negotiator. And if you don't think about it ahead of time, you might take an offer that sounds good to you in the moment, but then when you go back home after you sign the agreement and you look through all of, your pay stubs, like how much am I getting paid? How much am I going to get back? Is it tax refund or what have you? Like you go like, oh, I can't do this. You look at your monthly expenses, like I can pay 50, but I said I'd pay 100 a month. There's no way I can do that. Don't be in that situation, because once you sign something in civil court, it's really hard to undo it. It's hard in any court, but civil court, it's even harder. So figure it out before you start negotiations. The other thing is figure out what bargaining style works for you. Like I think what is most common is people want to agree on a number. So let's say the number you want to pay is $3,000. So you say, I'll pay you $1,000. And then they say, no, like 5,000. And then you'll go, okay, I can do 2,000. And then they'll say, no, 4,000. And you'll go 3,000 and that's it. And everybody says 3,000. Okay, we can go home now. That's one way of negotiating that's really common. Some people are really comfortable doing that. Some people are not. It's also totally fine to say, I'll give you $3,000 and that's it. That's the maximum I can give you. And then they can say 4,000, they can say, give me 5, and you can say 3, and just keep saying it over and over again. And eventually they will believe you that that's the most you're going to pay. So there's a lot of different ways you can negotiate. Just figure out what works for you. You can also, knowing the strengths and weaknesses both of your case and their case can be extremely helpful. You can use your strengths and their weaknesses as bargaining chips. And when I say bargaining chips, I really just mean putting pressure point, hitting their pressure point and persuading them to settle. So for example, first of all, if your income is exempt, if it's protected from debt collection, if it's like Social Security, that's your only income and that's not going to change in the future, you're in a really strong bargaining position. You don't have to agree to pay anything, because even if they get a judgment against you, they're never going to be able to collect on it. But if you're having temporary financial difficulties, so maybe you're on unemployment now, which is exempt, but you think you'll be working in like a few months, so you are going to have income, and it's going to be enough that they could come after you, freeze your bank account, or take money out of your paycheck if they win a judgment at trial, then you need to take that into consideration. But if you do have exempt, and some people, even if they have exempt income and it's a permanent situation, they still want to pay. They feel like they owe the debt, so they want to pay it. That's fine if you want to do that. But most landlords, they get over on a lot of tenants, so don't feel bad if you don't pay them. They would not still be in business. They know that some tenants aren't going to be able to pay rent, and a lot of tenants don't, and yet they're still making money, because if they weren't, they wouldn't still be in this business. So don't torment yourself. But if you have the money, you want to pay it, and it will give you peace of mind, go ahead and do that. So sorry, I got a little off track there with my chatting. But anyway, if you have exempt income, that is a really strong point that you want to make to them. Like if you want something, you can go through all this time and expense and you're still not going to get anything out of me. But if you enter into settlement with me, like at least you'll get something. Another strength is if service was improper. If they don't settle the case and you win a hearing, a traverse hearing saying that you weren't served properly, they lose, right? The case ends. They may be able to start a new case, but that's expensive, and they have to go back and explain to their client that they screwed up, they didn't give you the papers right, and that makes them look bad with their clients. And they're also out all the money they spent on doing the traverse hearing. So the threat of going to a hearing on whether or not you were served properly can put more pressure on them to accept whatever offer you've made. If you've gone through discovery and you see they don't really have the documents, like maybe the court papers say that you broke your lease and they don't have a lease, like you didn't have a lease at the time. They can't prove that you broke a lease that didn't exist, right? So that's another type of proof. If the amount they're suing you for, maybe it's, I mean, it may be a lot of money to you, but it may not be, it's less than what it would cost them to go to trial. So if doing a traverse hearing in a trial is going to cost them, $5,000 or more, and they say you owe $3,000, it doesn't make sense for them to go forward. They should accept less because, otherwise they're going to end up out money instead of gaining anything from the lawsuit. If you have strong defenses, like you have pictures of horrific conditions in your apartment, abusive letters or texts from the landlord refusing to make repairs, voicemails they left you, that kind of thing, don't feel like, don't hold back on sharing that information because they do not want the judge to see that stuff. So they might as well settle the case. And if you have no really strong defenses, but you have really compelling personal circumstances and you're okay with discussing that with them, some people are very private. They don't want to disclose that stuff. But if you don't mind, like if you lost your job because of COVID, there was a death in the family, you had a catastrophic illness and now you're disabled, or you were in an accident and now you're permanently disabled, sometimes telling them that stuff will have an impact. As heartless as many of these people can be, when they're confronted with that sort of information on a personal basis, sometimes it does persuade them to settle for less, especially if it shows like they're not going to be able to collect on a judgment. This isn't a temporary bad situation you're in, it's like permanent. You have a lot of time to discuss settlement. It's not something you have to rush into. As I said earlier, you can, often it's better to wait till after discovery. The judges have a lot of cases to hear and trials take a lot of time. So they always want people to settle. So they'll, even on the day of trial, they'll be asking you if you want to settle to see if they don't have to go ahead with the trial. Just so you're aware of that as well. If you feel like you're not a strong negotiator and that you're going to be so anxious, you're not going to be able to really get the result you want, you don't have to negotiate one-on-one with these people. You can ask for the judge or a court attorney to be involved when you talk to the plaintiff. The problem with that is sometimes the judges and the court attorneys aren't always helpful, but if you, it does, the attorneys can be very abusive and very bullying and very intimidating if you're speaking to them alone. So at a minimum, they will have to behave somewhat more politely if they're in the presence of court personnel. So there is that advantage. If you are someone that may get flustered in the middle of doing a negotiation, it's totally fine. Make some notes ahead of time. Remind yourself what numbers work for you. Make a list of the stuff, the points you want to bring up to them about the problems in their case. And then you can always take a minute to look at them. You can say, I need a break, or I need to think about this, and take some time and do that before you start again. And again, if you feel pressured to accept a settlement you don't want, or feel like the negotiation is not going well, you can absolutely ask for an adjournment and say you need time to think about it, or to consult with an attorney. Depending on your comfort level with risk, if you decide settlements you don't want to waste any more time on settlement talks because it's not going anywhere, ask for a trial date. And maybe by the trial date, they'll give you a better offer. So what sort of terms get put in stipulations of settlement in civil court? It's a little different than housing court. If you have that experience, the way stipulations are written in civil court can be quite a bit different. So in civil court, we're talking about money judgments. I think I already said they can't evict you, so there's no judgments of possession giving them a right to your apartment. There's just language about their right to get a judgment for a set amount of money, and that's the piece of legal document that they need to be able to collect money from you through a wage garnishment, getting a marshal to take money out of your check, or by freezing your bank account, that sort of thing. So unfortunately, and I don't know the history of this, but I know I was shocked as a housing attorney when I started in civil court that a lot of the unrepresented consumers were ending up with stipulations that said that the creditor would accept, maybe you owe $10,000, but the creditor, in this case, it would be the landlord, would agree to accept like 7,000. And in housing court, you would be done, right? Would say like, okay, you're going to pay $7,000, you're done. That's usually how it would work in housing court. But in civil court, they include language that if you don't make the payments you've agreed to on time, that they can revert the amount you owe back to the original amount you were sued for and collect that amount, enter a judgment for that amount less any payments you made. So for example, you're sued for 10,000, the landlord says they'll take 7,000. You pay 6,500 out of that $7,000, and then you miss a payment. Even though you only owe $500 of the $7,000 you agreed to pay, the language in the stipulation will allow the landlord to get a money judgment against you for $3,500. The $10,000 minus the amount you paid, the $6,500. So that is something to really read and look at and understand. And it's hard if you're if you don't have a lawyer to get them to not include that language. It kind of depends on if the landlord's attorney usually is in civil court or if they're from housing court. So but it happens more with the attorneys that practice regularly in civil court that you'll see this language, and with the ones that are more often in housing court and just kind of dipping their, just sort of occasionally going to civil court for a particular client. You may have more success in saying, no, I want to agree to that. But the civil court judges, they're very used to this. And so they don't think it's out of the ordinary. They're totally fine with it, even though it's really unfair. But they say like, well, this is why it's pressure to get you to comply with the agreement and pay on time. So it's really important to read the stipulation and see if they've asked for something like that. The other thing that they slip in a lot is that they can enter a money judgment if you miss a payment without further notice, as long as they serve you with a 10-day notice to cure. So that's kind of a combination of the next two bullet points. So what that means is if you're supposed to be paying $50 a month towards this, it says you'll pay $50 a month by the 15th of the month, like every month until you pay off the amount you've agreed on. And then you miss 1 month, or maybe you made the payment and they just didn't get it. They have to send you a notice letting you know that you owe this payment and giving you 10 days from the day they mail it or email it to you to make up that missed payment. And then if you don't, then the stipulation usually says that they can enter a judgment against you without any additional court date. So in housing court, you have a stipulation that usually says you have to make payments by a certain date And then if you don't, the landlord can bring the case back to court and ask for a judgment. That's one way cases can be settled in housing court. But here in civil court, it's like nobody's going back to court. It's like they just get the judgment automatically. And there's usually also language saying about what happens once you pay the debt in full. And it usually says that they have to send you some kind of confirmation, a letter and or a file, what is called a satisfaction of judgment. It's just a form that says you paid everything, and they file that with the court. Sometimes they want release language, which is saying that both sides are giving up like any claims they have against the other, even those that aren't related to the case. So be really careful about that, because if you have a potential lead paint case against them because your kid tested high for lead and maybe experienced some adverse health impacts, and they put in this case about rent that you're giving up any other claims, like you don't want to then not be able to sue them for the lead poisoning. Now you don't have to agree to any of these terms, but they usually have a pre-printed form and they say like, well, I can't do anything. Like, this is what my client wants. You know, you can still say, no, I can't agree to that term. Like, can you go back and talk to your client? Or the judge will say that if you go speak to the judge about it. So that's pretty much it. Some of there are some tax consequences potentially if the landlord agrees to give up some of the rent arrears. It depends a lot on the individual circumstances of your case, and I am not a tax expert. I'm just this is not advice. I'm just kind of highlighting that this as a potential issue. If, for example, the landlord said you owe $10,000 and you settle the case for $7,000, it is theoretically possible, if the IRS sees that as forgiving a debt, that they will consider that income, what was waived, income to you. Because if you owed a debt for $10,000 and you only had to pay $7,000, they feel like you're getting $3,000 back. There's language that you can put in that can change that, and there's ways to challenge it if it comes up when, you know, if you get a notice from the IRS or what have you. But it's I have had some experience with clients getting notices from notices that were filed with the IRS saying that they owed money. So it does come up. So I just want to highlight it. You can talk to a tax person. I know Legal Aid Society has a tax clinic that's open year round, for example, a low income tax clinic, and they can answer questions about this. So if you need an adjournment, if you're worried about tax consequences and want to talk to somebody before you sign something, not necessarily a bad idea. If you don't have any money and you don't pay taxes and you don't anticipate getting a lot of money in the future, you know, there's a lot less risk of this impacting your life. But it can only help if you write that if they gave up some of the money and it was because you disputed owing it, or if it was a credit for a rent abatement or a rent overcharge or property damage or something, just write that in the stipulation, because then that shows that it wasn't income. And another thing you might want to put in a stipulation is that increasingly landlords are reporting rent arrears that are owed to credit reporting agencies like Experian, Equifax, and TransUnion, and they become part of your credit report and can impact your credit score. So you may want to put something in the stipulation about how they're going to report the debt. The financial impact, again, something I'm really not an expert on, but the city has a free financial counseling program called the Financial Empowerment Center, and you can make an appointment to speak to them by calling 311 or by using this link. I know this is a lot to remember, and if you're in civil court and you don't deal with this issue, don't worry about it. Like, focus more on how much you have to pay and getting the case dismissed, that's your priority. But this is just so you can, think about it. Okay, let's say nothing works. You try to get the case dismissed, you're not able to. They won't give up on the case. They won't agree to settle the case. You're going to trial. What do you do? So again, if you can, talk to an attorney. Attorneys do trials all, frequently, and so they know best how to prepare. I would say in civil court, the judges are much less helpful about explaining trial procedures than housing court judges are. They're much more hands-off. They don't want to explain things, which is one of the reasons I included the glossary at the end of some of the terms that you'll hear in civil court. It's because sometimes you feel like the civil court judges are speaking a different language and they don't understand you unless you use that language. So it can be helpful to familiarize yourself. The other problem is, aside from the fact that civil court judges are less likely to intervene because they don't want to seem like they're more on your side than on the landlord's side. They also have much less familiarity with housing law because the rent arrears cases, though there are more and more of them being filed, are still pretty uncommon. So they don't necessarily, you may know more about housing law than the judge who's going to try your case. And I'm not exaggerating. That could well be the case. As I also mentioned before, typically the judges, they don't want to do the trial. It takes a lot of time. They have to write a decision. That takes even more time. So they will try to get the parties to settle before going ahead with the trial. And if the landlord shows up and has no witnesses or asks for an adjournment, you can ask for the case to be dismissed. If they're not ready for trial, the case can be dismissed. Sometimes the judge will specify that they can bring the case back, but sometimes they'll dismiss it and say the case is permanently over. Here's some tips on how to prepare for trial. Get together all your documents, photos, receipts, other evidence you have, originals if possible, that will help you prove your defenses. If you can, it's good to bring multiple copies, a copy for you to refer to, a copy to show the other side, and the original to give to the judge. But if if it's on your phone or something, what are you going to do? If you have pictures on your phone, just bring your phone. Because people are often sued years after the rent was owed or they moved out, it can really be helpful before you go to trial to write a timeline about when things happened, just to have it fresh in your mind. You should also write down a list of questions for the landlord's witness. Like usually that would be a managing agent. Sometimes it could be a super, but more often it's whoever kept the books, the accountant, to say like, here's our rent breakdown, here's what they owe. And write down a list of the evidence you have to prove your defenses. So if you have receipts to show you made rent payments that aren't reflected in the tenant ledger, like bring those with you. If you have emails from the landlord that back up what you said happened, if you have pictures that back up what you said happened, just bring them with you. You have a right to question the landlord's witnesses, and the landlord has a right to question your witnesses. Since you and the landlord are probably going to disagree about certain facts, the judge is going to have to decide who they believe. So to make that decision, judges consider the amount of detail the person gives about what happened and when it happened, how confident the witness is when they testify, how sure they seem about the facts. It doesn't mean you're obnoxious and you're like, everybody has to believe me. It just means like you can testify to things and the judge can tell that you mean it, basically. You're not waffling about things. And whether the witness says, what the witness says is consistent with the documentary evidence, and in some instances, common sense. Like sometimes landlords make crazy claims, like that you caused a ceiling leak. Like, how would you do that? Were you splashing water up on the ceiling? Like, how can that be your fault, right? But they'll still say it. Other tips, always tell the truth, because if you don't, like, you're not going to be able to keep track of stuff, and you're going to be inconsistent in your testimony, or, and judges, like, they may not always know when someone's lying or telling the truth, but they have a sense. Some of, they've been doing this a while. If you're not sure about something, say so. If you have to say, if you're trying to say like when something happened and you don't know the exact date, just say so. I don't remember the exact date, but then give as much detail as you can. So maybe you can say it happened in the winter of 2016. I remember because that's when my kid turned 4, and it was right around the time of her birthday, and she was born in February, or it happened in the summer, or maybe the month, even if you don't know the day. And if it's something like you didn't have heat and hot water a lot, but you don't know every day that happened, then just say how often it happened. Like, it happened in the winter, it happened like 3 times a week, or it happened every night, after 10. They wouldn't give any heat between 10 and 6 a.m. Whatever it is that you are sure about, like, say that. If you're being questioned, make sure that you answer the question that is asked. Listen to it carefully. If you need to, take a minute, not a minute, take a moment before you answer. And if you don't understand the question, say so. Ask them to repeat it if you're not sure what was said, or ask them to rephrase it in a way that you can understand. If you're talking about repairs, don't just list them, explain how they affected your life physically and emotionally. So if you had no hot water, talk about how you had to boil water on the stove to do the dishes, so it took twice as long. If you had no heat, how you couldn't sleep at night because you kept waking up, trying to check on the baby and make sure they were warm and hadn't thrown off their blanket. If you had bed bugs, talk about how that affected your social life. You were embarrassed to have people over, or people who knew wouldn't let you come visit them because they were afraid they'd get bed bugs. Getting documents into evidence can be really hard. You have to convince the judge that your records are authentic and reliable. So you're going to need to explain what they are, who prepared them, if they were made close to the time something happened, how you got them. Just if they keep objecting and saying you haven't laid a proper foundation, or they shouldn't be admitted, don't give up. If it's important, just keep adding more detail, and maybe you can wear them down, and the judge will let them in. The other thing is, it's really natural to get anxious when you testify. Don't try to pretend you don't, you're an emotionless robot and you're calm. If you're anxious, you're anxious. And if you need a break, just say, I'm sorry, I'm not used to doing this. I'm really nervous. Could I have a glass of water? Whatever you need to do. If you need any kind of accommodation because you have a disability, which could include appearing by phone or computer rather than going to court in person, you can request it by calling the courthouse or using the online portal. I have a link here. Be aware that the court can take a long time to process these requests, so ask for your accommodation as soon as possible. You can ask for some accommodations on your court date, but some need advance notice. So like if you just need, if you're in a wheelchair and you're going to need, you can't, like, the aisles aren't wide enough for you to get through, but you could use a side aisle, those are things they could do on the day. But if you can't come to court in person, they're going to need to set up the tech stuff ahead of time. I think they have headsets that amplify sound, and they do have screens that will, sort of do closed captioning sort of thing. But it can take them a while. So give them advance notice if you can. If you have an accommodation for one court date and you need it for the next court date and the case has been adjourned, ask the judge before you leave if they can grant that accommodation for the next court date, so you don't have to go back to the portal. And if your request isn't granted before your court date, then, and you need it to go forward, ask for an adjournment. I'll also say, this isn't really for disability, but the The interpreters, there's fewer interpreters available in civil court, and you end up having to wait a really long time sometimes. I know that can be a problem in housing court as well, but it's even worse in civil court. So if you need an interpreter, don't be afraid to ask for one, but also know that it can take a while for them to get someone, and sometimes they may even have to adjourn the case. These are just some of the resources that are available. I already mentioned on an earlier slide that lawhelp.org/New York has, or NY, has listings of legal services organizations that can give advice or represent consumers. Unfortunately, there's no funding for this work. There are very few organizations and attorneys who can help. We are so overwhelmed with the need. I'm one of the few attorneys that does these. I'm the only one in my office that does it. And citywide, there's just a handful of us, really. Housing attorneys often can't take these cases when they're not in housing court because their priority is cases where eviction is at risk. And they want to prioritize those cases so they don't have other people to do this type of case. The other thing that I don't think I mentioned earlier, but if you're no longer living in the apartment, you're not going to be able to get like a one-shot deal. So that some people don't know that. If you are still in the apartment, even if you're, you can try, but if there's no risk of eviction, I'm not sure you'd be eligible. Every courthouse has a legal resource center. They can help people find the forms that they need and explain how to fill them out and how to file them, like answer forms and motion forms. They can't give legal advice, just information about how the court works, and they can sort of explain the papers. So it's some help, but it's, not a lot. In some courts, there is a volunteer lawyer for the day program. They can't represent people except on the day. So they usually don't do trials, but they can help you if you have a motion to explain to the court what you're asking for. They can help you. Sometimes they'll do the traverse hearings. They can ask people. They can help people negotiate settlements. That's sort of their bread and butter. And they can also help people ask for adjournments. But their focus is the credit card cases and other types of debt. The rent arrears cases, there aren't a lot of them. And so they just weren't, when the program started, the volunteer lawyer for the day, it didn't really include rent arrears cases. So sometimes they'll try to take them, but they're busy enough with the cases they've been assigned to, so you can't count on it. The court website has a lot of do-it-yourself sample forms and information, so you can read it. It's not really geared necessarily towards rent arrear cases. A lot of it is credit card cases. I find that some of the information for small claims cases are helpful because they talk about how to prepare your case. The rules of evidence don't apply to small claims court, and typically you can't get discovery. So it's not like a perfect fit, but it can give you some general practical information on how to prepare your case. And another thing I suggest, if people are able to, is the courtrooms are open every day. So if you have time and are able to, it can be helpful to just go to court before your court date and see how things work. It can take away some of the anxiety. It can show you what to expect. And sometimes you can pick up some stuff. You can learn some stuff looking at how people are addressing different cases. As I said, most of the cases aren't about rent arrears. So it's not it's not a perfect fit, but it does give you some general ideas of how court procedures work. And I'm not going to go over the legal vocabulary, as I said before, because we already, this is for your reference if you need it. So that is it for my PowerPoint. So if people have any questions, I am happy to answer them.
Thank you so much, Mary. That was very informative. And we do have some questions. I'll go ahead and start reading them off. The first one is it different for tenants that don't have a lease and are living in an illegal apartment?
So if it can be, depending on what we're talking about. So I can't give legal advice, and there are a lot of different things that go into that equation. But generally, I think I told you that if you don't have a lease, you can still be sued for use and occupancy because you're getting some value from the apartment. There's particular laws that apply to whether or not landlords can charge rent when someone is living in an illegal apartment, and they have been interpreted differently by different judges to apply depending on the circumstances and how illegal the apartment is. So sometimes if you live in an illegal apartment, the landlord might have a really hard time getting a judgment against you for money, but sometimes they can. So yeah, it's different in that it's one more thing you can bring up. So it's a defense. But if you are living in an apartment that is illegal, you should definitely bring that up as a defense and say you shouldn't have to pay rent because the apartment was illegal. And you can also, if the conditions were bad, sometimes they're illegal technically, right? Sometimes it's like they don't have the window or, and sometimes it's, it's like there's no working bathroom, that is obviously like a bigger issue. And you can, if there are bad repair issues, that doesn't matter if it's legal or not, like you still shouldn't have to pay rent when the conditions are so bad. It's really not livable.
Great. Second question, can the landlord charge a late fee if the tenant pays on time, but they have arrears?
That is I've never heard that coming up, but this is how I think that might come up is some landlords, some leases say that your rent will be credited towards the last month you owed, or sometimes you sign a stipulation in court that says that money paid will be not will be applied to the last month owed instead of to the month it's paid in. So that might be a situation where a landlord is, you didn't pay a certain month, and so every month that you pay after that, they're applying to the month before. So they're saying you're not paying the month on time. Like whether or not they can do that, I can't answer that question because it's, it really depends on the facts. But you would need to look at your lease, and it's definitely something you could raise and say, like, I wrote on my check that this is for this month, but they credited it for another month. It comes up sometimes too if you have a shelter allowance that's being paid by public assistance and it's paid twice in the month, and it says your rent is due on the 1st. There's definitely a law that says they can't do that, but I still see it happening. So bring it up. Definitely, it's important to raise. But I can't say what a judge will do with it because it just depends too much on the facts. And also some of the judges, like I said, they just don't know housing law at all. So it can be challenging.
Great. Next question is, can landlords accept rent once they file a non-payment?
So that's a little outside the scope of this program, but because I used to be a housing law lawyer, I think I can answer that. So the only time landlords cannot accept, usually landlords refuse to accept rent in a holdover because they send you a notice saying like, we're terminating your tenancy because you're a nuisance or you're not a legal occupant or whatever. So if then they accept rent after that, like they're saying you're a tenant because they can only take rent from a tenant. So there's a window of time after they send you that notice and before they file a court case where they can waive their right. They can vitiate the notice, it's called, make that initial termination notice invalid by accepting rent money. So that's why they're afraid to accept any money in a holdover like ever, because they don't really understand the timing. But there's nothing like that in a non-pay. So I haven't seen that. But if they say you owe a certain amount of money and then they sue you and then they don't take and you offer them rent, they might not want to take it if it's not the whole amount. Sometimes they worry that they're waiving their rate. They're saying like, oh yeah, you can just pay me a little at a time or something. So it does come up, but there's nothing that I'm aware of that prevents them from being able to do that. It doesn't make them lose their court case or anything.
Okay, next question is, can a landlord file a holdover case while a tenant has a lease? Often people do not have leases, but I thought all rights remained.
Okay, again, not a civil court question. So, basically a holdover is when you're saying the tenant either doesn't have a right to be in the apartment because they don't have a lease. Like maybe they're a squatter, maybe they just the lease expired and they didn't get a new lease. Maybe the tenant let them move in, but the landlord never said it was okay. And that tenant moved out and they're like now in a different legal category. But it can be for it's either because you broke your lease by not doing something you're required to do in the lease that isn't related to non-payment of rent. Like you ran through the hallways naked, screaming at night, or set fire to the building. You might be a nuisance. Or your lease says you can't make improvements to the apartment without the landlord's permission, and you put up a partition or painted it, whatever color you wanted. Like theoretically, you broke your lease. So, the landlord holdovers can be about all kinds of stuff, and you may or may not have a lease in effect. But to bring a holdover, they generally terminate. They send you a notice of termination to say we're terminating your lease if you have one in effect, and if you don't have a lease in effect, they send you a different kind of notice saying like, okay, you've been there, but we want you to leave because you're not really a tenant because of this. So go away.
Great. Next question is it legal? I guess it would be, was it legal if the landlord gave you arrears or charged you for arrears during the height of COVID?
So COVID, there was a moratorium on evicting people during COVID, but there was nothing saying you didn't have to pay rent during COVID. So there were conditions about whether or not they could evict you for paying rent, and there were different programs that might help you pay rent arrears if you owe them, but there was nothing that said like you don't have to pay rent like because of COVID.
Okay. Next question is, what if you paid the rent arrears already and it was a great hardship for you to pay? Can you get a refund from the landlord?
So that would depend on a lot of things. Like if you had bad repair problems in the apartment and you paid your rent and then you want to sue the landlord and say, I deserve a rent abatement, like in small claims or whatever, because of bad repairs, like you can get money for a rent abatement. But if you want a refund of something, there has to be a reason for it, right? And it can't just be because it was hard for you to pay. Like that's not a legal defense to owing a debt. Like sometimes it can be persuasive. Sometimes you say stuff like that and you ask people, to do something that you think is morally right, but they're not legally compelled to do, but you bring up stuff and it might persuade them. But there's no law that says you're entitled to get money back because it was hard for you to pay it.
Right. So the next one, we may need some clarity, but it says, can a landlord allow you to be messed with if you take them to court?
I do not know what that means.
Yes. Can whoever wrote that question maybe rephrase it or add some clarification? And we'll move on to the next one and circle back. How do you request a traverse hearing?
So it's usually there's two different ways. One is your case is marked down for trial, and you brought up in your answer that you weren't served properly, and you say, I want it to be a traverse and a trial. And the judge can just write down, okay, traverse and a trial. The other way is if you're not ready to go to trial yet and you don't want to have to go to trial right away, if you lose the traverse, then you can make a motion for a traverse hearing, which is a written request. And you're basically saying, I wasn't served properly. This is why. So I'm asking the court, this is why what the process server said is wrong. I never got the papers. So I would like a traverse hearing. And then the other side has a right to say, like, no, they shouldn't have a traverse hearing. But as long as you say you were not served and give facts to support your claim that the process server, was wrong in what they said about serving you, then generally the court will give, they'll still give you that traverse hearing, even if the other side says they don't want you to have it.
Great. The next question is, if all the arrears are paid, can the landlord still evict the tenant?
So if we're talking about civil court, if you're sued in civil court is only about money. So if you don't pay a money judgment, you can't be evicted for it because it's all about the money. The only thing that the landlord can do if you don't pay it is they can take steps to take the money from you involuntarily this is a really good question, by the way. I should, now that I'm thinking about it, of course, people would not know that. I know it, but so if you don't pay it and the landlord has a money judgment, they can freeze your bank account to pressure you to pay, or they can ask your employer, if you are working and earn more than $450 a week take home, you can they can ask a marshal to do those things. In theory, they can do other stuff, like they could try to get, if you have other assets like that are not in a bank, but like you have valuable property, or if you own a house or, a car or something, they could try to take that from you to satisfy and then sell it to get the money to pay off the judgment. But that's pretty uncommon. They have to find out that stuff exists. It's kind of a pain. So, but no, if you're in an apartment and they decided to take you to civil court instead of to housing court, they're not able to evict you. There's nothing that can happen in civil court that will give them the right to evict you. They have to go to housing court for that. Or if you're in an illegal apartment, that there's some weird stuff that happens with that. They may have to go to another court to do that. But we're talking about civil court cases where they say you owe money. If the papers they give you just say, like, we want your money, that's all the case is about. It's just about the money.
Mm-hmm. Okay, next question is, if the landlord decides to keep you as a tenant after the arrears are paid in full, are they allowed to increase the rent right away?
So this is a question that is really about, I think, the emergency rental assistance program, that if landlords got money through a COVID program to pay the rent arrears, one of the things was like there were some conditions, and I'm not an expert on this, but I think one of the things was like they couldn't evict you for a year or whatever. So like in civil court, it's just about you owing the money. And if you pay the money, then the judgment is gone. It's what is called satisfied. It no longer exists and you're done. And if you don't pay the judgment, they can keep going after you until it's paid. Except, like I said, they're good for 20 years. So if you make no payment or do anything else that would reactivate them, like they can keep trying to get this money from you for 20 years. It has nothing to do with whether or not they can renew your lease. It has nothing to do with your possession, your right to live in the apartment, your possession of the apartment. Civil court is only about the money. if you live in an apartment that's rent stabilized and they have to give you a renewal lease, whatever happens in civil court, like that's not going to change your rights. If you live in an apartment that's not rent stabilized or where you don't have a right to a renewal lease, like the landlord can do whatever they feel like when your lease ends, whether or not you pay the money. It doesn't really change anything. But obviously, if you're not paying your rent on a regular basis and you owe money, and if you don't have the right to a renewal lease, like is the landlord maybe gonna not want to renew your lease? Like, yeah, it's likely. And if you're not rent regulated and it's up to them how much they want to charge in rent, if there's no law that limits it, they can charge whatever they feel like whenever your lease ends.
Great. Next question is, can a tenant whose only income is SSD be sued for rent arrears?
Absolutely, you can be sued. It doesn't, so the fact that the landlord still has a right to sue you if you owe the debt, regardless of what your income is. Your income only, the only effect your income has is on whether or not the landlord can collect on the debt if they get a judgment saying you owe it. So a lot of times landlords don't bother suing people when their income is Social Security because they know even if they win their case, they can't collect unless you pay it voluntarily. There's nothing they can do to make you pay it. So a lot of them will just like, it costs them money to like sue you in court, right? And go to a trial. So a lot of them won't bother, but some of them just get really spiteful and do it for what they call the principle, or to like, set an example, like to show people they're tough or whatever. So yeah, they can still sue you. It doesn't stop them from suing you being on Social Security. It just stops them from being able to collect money pursuant to a judgment if they get one.
Okay. Is there a limit to the amount of financial help for one-shot deals? I don't know if that's something you can answer. That sounds like an HRA question.
So I think I touched on this, but generally speaking, except during the pandemic, one-shot deals were not available to people who are not at risk of eviction. So because a civil court case is about money and not about possession of the apartment, they're really one-shot deals generally have not been available, except like I said, in a very exceptional circumstances, like during a worldwide pandemic. They relaxed that rule. As far as I know, that's no longer the case. So that's what makes these cases really hard, is that there's no legal, there's very few attorneys that are able to help you with it. And they're charities and generally HRA, they don't want to give money for rent arrears if it's not going to keep you in your home. So if there's no risk of eviction, like it doesn't, if you get a judgment against you, it may affect your ability to pay bills. And I think it's short-sighted, frankly, because if you have a judgment and somebody's garnishing your wages and taking like 10% out of your paycheck every month, and then you aren't able to like pay your bills, then, you could end up at risk of eviction, right? But they don't look at it that way. One other thing I didn't mention is that sometimes there is an option to file for bankruptcy, but there can be a downside. And depending on what type of bankruptcy you file, like you may or may not have to pay the rent arrears. Like some debts, if you file for bankruptcy, they're what is called discharged. They're no longer collectible. And that's one type of bankruptcy, and the other type, you have to do a payment plan or whatever. And I don't do bankruptcy. I just went to a training once, and that's all I remember about it. But you can, there are places you can contact that provide bankruptcy for low-income people for free. If you find yourself in a situation where you have a judgment against you for like $50,000 because you couldn't pay during the pandemic, and maybe you, for whatever reason, you weren't able to get help through any of the COVID relief programs, or maybe it's rent arrears that happened after COVID. Like you can look into bankruptcy. It's not an option for everybody, but you can check it out and see if it would work for you.
Great. Okay, next question is the fact that a case is a holdover case precludes it from entering into the civil court system?
Oh, that's an interesting question, and kind of complicated. So holdovers are different, right? Holdovers are about who gets to live in the apartment. Like non-pays are about money, but with the threat of eviction hanging over you. So non-pays are similar to civil court actions in that they both at least have a money component. Holdovers are generally about like, we want the apartment and we want it, even if, like, I used to say when I did housing trainings and non-pays, you pay, you stay, right? Because it's all about the money. If you can pay the money, you can stay. But in a holdover, it's not really about the money. It's they want the apartment. So even if you don't owe any money, they can still evict you. Um, if they have a non-payment, what I've seen happening sometimes is landlords sue a tenant both in housing court and in civil court for money. So they have a non-pay going at the same time they have a money case going in civil court. You can't have two cases going on at the same time looking for the same relief. So like you can't sue someone for the same money at the same time in two different courts. Like they're not allowed to do that. But for a holdover, if they're not trying to get money in the holdover case, there's nothing to stop them from going to civil court and starting a case at the same time. But I've never seen that happen. What I see happen is after someone's been in court on a holdover for like 5 years and it finally goes to trial and the landlord loses and the landlord didn't accept rent for 5 years because they wanted to stick it to the tenant and try to and counted on them not being able to pay, you know, and being to evict them, able to evict them in a non-pay after if they lost the holdover. Sometimes I see like they decide to go to civil court to sue for money that came due during a holdover, but it's after the holdover is over. And I think they're going to civil court more for things like that because there is no right to counsel. So they know it, you know, that it's much easier for them to win if there's no one available to give advice to the tenant in the case or to represent them. So it's a really attractive option for them. So I have been seeing that happen more. I hope that answered your question. I know I was maybe too technical, but basically no, like the holdover is a different deal. So they could, if they're suing you because they say you're a nuisance and you know, they could still sue you for use and occupancy in civil court. It doesn't really make sense because they could do that in housing court anyway, but they might choose to do it for whatever reason.
Right. Are landlords allowed to use security deposits to pay off any arrears?
They can, yes. So most of the time it's often the tenants asking for that to be an option. And again, I'm not a housing attorney anymore. And I remember vaguely during the pandemic that there was some kind of proposal that people could use their security, you know, kind of as a loan to pay off rent arrears and then replace the security deposit later after they got back on their feet. I don't really remember like if that's still in effect. Generally, if the parties agree, like if you and the landlord agree to if you're moving out and the conditions in the apartment are okay and you don't want to pay the last month's rent, a lot of landlords will say like okay to that. So if both sides consent to that, it's okay. But if one side says no, I don't want to apply the security to the rent, then as a general rule, there can be exceptions, but as a general rule, like then you can't do it.
If the landlord lost in housing court, can they try to get the arrears in civil court?
Yes, and they do that. I think it kind of depends on why they lost in housing court. So if there was a trial and after a trial, the judge said, this tenant doesn't owe this money, that's it. The landlord doesn't get what they like to call a second bite at the apple by like suing again to try and get a different decision on the same thing. So they wouldn't usually be able to do that. But there's something called a case being resolved. I thought I had a slide on this. Maybe I cut it because I thought it was just too long. but cases can be resolved a couple of different ways. Like and it usually says this in stipulations, like that the case is discontinued with prejudice or without prejudice. And I know that that doesn't, you hear prejudice and you think bias, you think, discrimination, but that's not what it means. It means with prejudice means you're done. You can't bring this case back. It's resolved permanently. Without prejudice means like we're withdrawing this case for some reason, but not because we think the money isn't owed if it's about money, but for some other reason, like maybe we didn't serve the papers right, so we're going to withdraw it without prejudice so that we can start a new case and do everything right the next time. So sometimes for technical reasons, they'll withdraw it without prejudice. So if you had a housing court case that ended and there wasn't a trial and a final decision, but it just got withdrawn for some reason and it was without prejudice, then in theory, yeah, they could go after you. They might not always succeed. It's really fact specific depending on what happened. But in theory, yeah, they could bring a second case in civil court after a non-pay. And it depends on what you mean by lose. Like maybe they partially lost. Maybe the case got dismissed in housing court because they sued for late fees and repair charges or utility fees, and housing court doesn't have the authority to hear those cases. So they can dismiss that case without prejudice so they can bring it in the right court. So if somebody brought a case and housing court wasn't the right court, it could be dismissed and they could lose that case and still be able to file it in the right court later on.
Great. Okay, is there a way to make a payment directly to the court? Often landlords try to say they have not received payment.
So if you're talking housing court, there is a way to deposit your money into court. It's kind of complicated and a pain, and the court hates the paperwork. So it is an option that is not commonly used, but there is a way to do it. And if you're in housing court, you'd have to ask about that option. I can't really tell you how to do it. It's not something I do because I'm in civil court. Civil court, there isn't really any similar process, but if because they're not talking about money you're gonna owe in the future. So basically, if you're in a situation where you're sued in civil court and you keep paying money and the landlord keeps not accepting it, you could bring money, you could pay the money like on a court date in front of the judge and do it, or you can send it by certified mail to show that they got it. And then if they don't cash it, like if it's a money order or what have you, then it's kind of on them, right? Like that can be a defense if you offered the money and they refused to take it, potentially.
Next question is, what can be done if your landlord says they never received money from a one-shot deal and collected money from someone with limited income?
If you had a one-shot deal approved and the landlord says they didn't get it, there's usually in housing court, there's somebody from HRA, I believe, in the courthouse, and you can go and ask for a printout of when and how that one shot was paid. And if it shows that the checks weren't cashed, you can ask for them to be reissued. And then if you've already paid that money and then they get that money paid again, you would have then you would have a rent credit for the amount that was basically double paid. And you could ask for a refund, but I don't know if the landlord would agree. There's nothing There are no one-shot deals in civil court, so I'm assuming you're talking about a housing court matter.
Next question says, if the apartment is illegally listed as commercial, will the landlord be allowed to evict the tenant?
Okay, so again, I'm the money person, not about the eviction. So I can't really answer that. I mean,
Mhm.
it's different. Commercial property, there's a different procedure for that landlords are supposed to go through. So, if they're generally, if an apartment is illegal, like if you're living in a commercial space that's not supposed to be a residence, like you might argue you don't have to pay rent because like you paid for a residential apartment and it's like not a residential apartment, it's like a store with a bathroom. So that's something you would bring up as a defense, but you need to talk to a housing attorney about that. That's not something I can really answer. I can just tell you that commercial cases are not brought in housing court. So there's a whole different procedure to deal with them, but I don't represent people in commercial cases, so I can't give you a lot of details because I represent individual tenants, not store owners or people running stores.
Okay. And our final question, just trying to clarify it. It looks like it says landlord demands monthly late charges during a holdover proceeding. Because by its very nature, outside of a stipulation, it wasn't possible for them to deposit any payment. Sounds like housing court again, but
So, I mean, there was a law that was passed, the HSTPA. I forget what it all stands for. But anyway, there was a law that was passed in, I think it was 2018, and it limited what a landlord could sue you for in housing court. I know there's been some fighting over it, but I believe that late fees was one of those things. So they might not be able to sue you for, they might not be able to get late fees in housing court. They might have to sue you in civil court for that. If that answers your question, but I can't really say what's going to happen in a holdover, because I don't know, because I don't do that anymore. I just go to civil court at this point. And, we need more people. There's so many housing attorneys now, so many more than when I did housing. I feel like it's so unfair because when I did housing, we had not enough attorneys, and then I moved to civil, and now there are so many more housing attorneys and so many more resources, though still not enough, but it's much better than it used to be. So I spent all that time fighting to get more resources, and I didn't stick around long enough to enjoy the benefits. So now I'm fighting in civil court. Yeah, it's like most people don't end up in civil court, honestly, but like I said, I am seeing it more. There's a couple of different reasons why. Like one reason is because during the pandemic, there was a moratorium. They stopped eviction proceedings. Like you could not evict tenants during COVID for like quite a lengthy period of time, but you could still sue them if they owed you money. So a certain number of landlords started going to civil court. Not that many, because there was also rent money available or rent grants available to people during COVID, specifically because of the pandemic, so they could get their money through an application without even having to sue anybody. So why sue somebody? But a few of them ventured into civil court, and now they know that there are no attorneys representing tenants in civil court. And because of law reforms in the HSTPA that limited how much landlords can get, landlords used to have this huge financial incentive to evict tenants because they could up the rent for rent stabilized tenants by a ton of money, both for getting a vacancy increase, like just being able to increase it just because it was a new lease. And they could also get a ton of money for renovating the apartment and then adding that cost or a portion of that cost onto the rent. And so both of those things are no longer true to the same extent. Like they can still get some rent increases, but it's not as much. So landlords have a lot less incentive to evict tenants than they used to. So a lot more of them are like, just give us our money, because like, people, we can't get, it's not worth our while to evict everybody. That costs a lot of money, and then we can't up the rent as much as we want. So they're saying like, just give us the money. So now they know they can go to civil court and there's no right to counsel. So they're, it's easy pickings for them. Like people show up, they're disoriented, they don't know how anything works. That's why we're doing this training, to try and get people some confidence so that they can fight back to the extent they can. And I am seeing more and more of these cases. And another weird thing that's happening is I'm seeing a lot more identity theft cases involving leases. So I'm seeing people being sued in court on leases that they never signed for apartments they never lived in. And so people are finding themselves in civil court, like on rent arrears cases that they definitely don't owe. And yeah, I've had a bunch of those cases lately, which is really weird. So even if you don't owe money, like you might end up in civil court on a rent arrears case, but hopefully not. But yeah, I mean, the other thing is, if you're in housing court and you leave things unresolved in some way, it is more likely now than ever before that a landlord will sue you in civil court. So if you signed an agreement a few years ago that said maybe people couldn't agree on the amount owed, they all agreed $5,000 was owed, but there's $1,000 out there nobody could figure out. They wanted to resolve the case and have a clean stipulation that said a specific amount so they could get a one-shot deal. So they said, okay, we'll agree $5,000, or we'll agree $4,000, and this other $1,000 we don't know, we can't figure out. We'll just set that aside, and the landlord reserves their right to seek it at a later time. Those kinds of stipulations are ending up now in civil court because they're suing in civil court for that money, because it's not about eviction anymore. It's just about, if you leave anything hanging, it can end up in civil court. And also the broken lease cases, when people move out when a lease is still in effect, we see those a lot. Or if somebody moves out and they tell the landlord they're moving out, but they're going to leave their niece or their nephew in the apartment and they'll take over the payments. And then, of course, something happens and they don't. And so the lease is still in that person's name that moved out. Like, see cases like that a lot. But most of the time, if it's just like you're in the apartment and you are renting the apartment, you are going to, most often you're going to be sued in housing court. But this training is about, what about the times when that doesn't happen and you end up in civil court? Like, then what do you do?
Okay, that's it. Ashley will wrap us up. Thank you so much.
Sure. Thank you guys for inviting me, if I didn't say. And thanks everyone for your patience and hanging in, because I know, oh my gosh, how complicated and dry is this topic?
Thank you, Mary. The presentation was wonderful. Thank you for everyone joining us today. We have other workshops. Feel free to join our to check our website and to subscribe to our newsletter. And we hope to see you all again. Enjoy your evening, everyone.
Yes, and our next workshop is going to be on the legal lockouts on June 2nd at 3. So please subscribe and join us. And thank you again, Mary.
Thank you, guys.
Bye, everyone.
Bye, Ashley. Bye, Monique. Bye, everyone else.
Bye.